an appeal in the matter of THTN and the Secretary of State for the Home Department.
Yes. Good morning, Mr. Chapter.
Good morning, my lords, my lady.
Before you do the introductions, can I just confirm that this is a case in which an anonymity direction has been given, and so of course we can refer to the appellant, but the appellant will not be named during the proceedings or in our judgment. Thank you.
I'm grateful, my lord. My lord, I appeal for the appellant with my learned friend, Mr. Ngora.
Yes.
My learned friends, Mr. Hanson and Mr. Wynard, appear to respond to the Secretary of State. My lords, I think first on the agenda today is the respondent's notice. The application for an extension of time.
Yes, well, it might be helpful, I think, if involving in due course Mr. Hanson also, if we did a bit of housekeeping. We're obviously aware that the filing of the respondent's notice caused some concern about various matters, including the time estimate for this application. And those matters came to us as a constitution towards the end of last week, at a time when we had only broad knowledge of the issues in the case. Since then, we've obviously read all the essential documents and your submissions about them. What I'd like to do is to, in an attempt to reassure you that the time that we have today will be, in our opinion, more than ample to resolve this matter. And in the knowledge that the parties came very close indeed to reaching a compromise. It gives some indication of the court's position with regard to the issues which are raised. In doing so, I want to make quite clear that we've not made our mind up about anything, that we are here to hear the appeal, if permission is granted to hear the respondent's notice, and we'll make our decision at the end in the light of all that. However, we need first, I think, to identify what the arguments actually are, and you'll know that there's some discrepancy between the grounds of appeal document and the skeleton argument that was filed.
Yes.
Could we resolve that now, please, so that everybody knows what we're talking about when we talk about, for example, ground 1, ground 2, and so forth? Is it convenient for you to work off the grounds of appeal document?
My lords, I think the skeleton would be easier because my learned friend has also used the numbering in the skeleton, and I think that would be far easier. I think, and my lord, I would say that broadly speaking, there are 2 grounds of appeal.
Right.
The first ground of appeal has a lot of submissions in it, but broadly speaking, it's that the court, the FTT, got it wrong on cessation, and the second ground is that the FTT got it wrong on the Article 3 medical ground. Those are the 2 broad submissions, and the first one has a number of substrands which also merge into each other. So there's overlap between the submissions on the cessation. I think the cessation argument is perhaps a little bit more straightforward in that the distance between the parties on the law is not very great. The law is fairly settled. We would say that there is some emphasis that was missing in the FTT's determination and in the upper tribunal's decision in PS with respect to the importance to be placed on UNHCR's observations. But apart from that, I think it's more a question of looking at what the FTT missed in terms of the evidence and its assessment in the context of a settled legal framework. On the Article 3 point, the legal framework itself is an issue, and it might be, if the respondent's notice is admitted, that we're looking at the detailed evidence that was before the FTT and whether the FTT dealt with that properly.
Well, I don't want to unduly hamper your argument, but I think it may help you to know that our current thinking is that in relation to what you now describe, as it were, as ground 1, and it's helpful to group matters in that way, essentially we feel that the ball is in your court. but that in relation to the Article 3 matter, our preliminary view is that the ball is in the Secretary of State's court. And so that may help you in your timings
Yes.
when you're advancing these matters. So far as the respondent's notice is concerned, you do not have to deal with the respondent's notice unless and until we give permission for it. And that's something that we will hear from Mr. Hanson about in due course. And if you then have to deal with it, you'll have our indication when you come to respond to it. You may not have to deal with it. We'll wait and see what the decision is there. But that at the moment, it seems to us that even if you were successful in saying, well, this is far too late for the Secretary of State to want to come back and challenge your prima facie case of Article 3 breach argument.
Yes.
It still leaves a situation where if you were to succeed in the appeal on the basis of Article 3 and the matter went back to the first tier tribunal, given the passage of time, now some
2.5 years.
2.5 and it would be 3 years before the matter got anywhere near the FTT again, they would simply have to look again at the whole health issue. And so, although you might score a, as it were, you might win the battle in relation to the respondent's notice, it wouldn't in the end make any difference, because there'd be no question of going back to the FTT with a preserved finding that you had succeeded at the first stage of the Article 3 argument. And so it may be, even on your best case there, that the respondent's notice doesn't really take matters very much.
I appreciate that, my lord. I'm grateful for that indication. I will make submissions on this in due course and more fully, but the appellant would seek to persuade the court that if it is with the appellant in relation to Article 3 and the first tier tribunal did make an error, in light of the state of the evidence before the FTT, with there being no evidence advanced by the Secretary of State, the position should be that the appeal on Article 3 is allowed outright, because there was no way in which the FTT could find that the Secretary of State had discharged her burden. That, of course, doesn't preclude a further assessment by the Secretary of State, but it does dispose of these proceedings. But well, I'll come on to that in due course, my lord.
You can come to that, but in any case, if you're wanting to get what you broadly described as ground one on its feet, we'll need to hear quite closely from you. But at the moment, you can deal relatively in summary with the Article 3 points when you come to them. Now, what is your, we've allowed an extra half an hour for this. How long are you going to need in order to present the appeal with those indications in mind?
I would hope that the cessation point and the Article 3, bearing in mind the indication and perhaps leaving any detailed submissions on that to a reply, could be dealt with within a couple of hours.
Well,
might encourage me to do it more quickly.
You must argue it in the way you like, but we must make sure that we allow for time for you to deal with any matters that Mr. Hanson persuades us you're going to need to deal with in due course.
And I take it, my lord, is intending to deal with the respondent's notice at some stage rather than at the outset?
Certainly, rather than at the outset, but I will come to Mr. Hanson before you embark. Don't feel you need to take the entire time estimate that you've indicated, but we'll see where we go. I'll just come to Mr. Hanson so he can say anything about the programme of work before we start.
My lord, that all seems eminently sensible. I don't anticipate being more than an hour and a half, all told.
I mean, clearly, we have experienced counsel. You'll respond to hindrances and assistances from the court as we go along, but we're clearly going to be able to reassure ourselves that we'll comfortably finish this hearing during the course of the allotted time. Good, thank you. Now, Ms. Jaffe, back to you.
My lords, my lady, I note that my lord said that the bench has had an opportunity to look at the papers in some detail since last Friday.
Yes.
Can I take it that the factual background does not need to be rehearsed and we can jump straight into the submissions?
You can.
I'm very grateful. If I could start then by taking my laws to the core bundle at page 70 and just quickly running through the FTT determination,
Yes.
just to get an idea of the structure of it, the way that the judge dealt with the overall issue. So there is, at the start, an introduction and then the factual background to the appeal. At paragraph 2, the judge deals with the grant of asylum in 2010 in the following way. The appellant claimed asylum on 10th March 2010. On 7th April, she was referred as a potential victim of trafficking and benefited from a conclusive positive grounds decision. On 19th October, she was
Yes,
granted
well, as I
asylum.
say, you needn't read bits from this
Yes.
unless they're essential. We have the history.
And then at paragraph 6, you have some reference to the claim as it stands now, but there's very little reference to the circumstances at the time that the positive asylum decision was made in 2010. The legal framework begins at paragraph 21. As I suggested earlier, there's no real issue with respect to the legal framework, and the appellant accepts that the first-tier tribunal set out the legal framework properly. The only exception is that the importance of UNHCR's views was perhaps not emphasised in the way that it should have been. The certification decision follows. That's not the subject of the appeal. The cessation consideration begins at paragraph 42. The assessment of the evidence is at paragraphs 48 to 61, with the conclusion being stated at paragraphs 62 to 63. And we say that the conclusion stated there clearly demonstrates that although the judge recited the law correctly, the application of the law to the facts was incorrect, and clearly incorrect, because the test that is stated earlier is not actually applied, and that is clear from the conclusion of paragraph 63. Article 3 medical grounds consideration begins at paragraph 70, and you have the conclusion at paragraph 80, and that conclusion clearly relates to the lack of treatment available in Vietnam, not that the threshold test, the prima facie case, has not been met. That is a broad overview of the...
Really, your target in relation to what you call your first ground is 63, and in your second ground it's 80.
That's right, but in relation to the first ground, the reasoning is also important, because although we say the test was... So the judge didn't ask himself the right question ultimately, and therefore didn't answer it, but also the evidence that he's taken into account is woefully inadequate when one looks at the content of the CPIN itself. So even if we disregard the evidence that was put forward by the appellant, the CPIN itself shows that the situation has not materially changed since 2010, and that there are serious concerns, not just in the country information section, but in the policy section itself, serious concerns about the situation upon return to Vietnam. And that is why the failure to look at the note of the reasons why asylum was granted in 2010 and consider that in at all, let alone in any detail, is a serious failing, because the comparison must be, and this is clear from the authorities, the situation as compared with the circumstances when asylum was granted. So what is the difference between 2010 and 2021? That exercise is simply not being carried out. But if I could just take my lords and my lady to very quickly through the law on this. The Refugee Convention is in the authorities bundle at pages 4 to 8. And if I could take you to page 6, which has the relevant provision. Article 1AC sorry, it's at page 7, 1AC,
Um,
and it's subsection
before
5.
before we look at these, a recent authorities bundle was sent containing, I think, nearly 1,100 pages. Which one are we working off? That one or the one that was previously filed?
The latest one, my lords.
Thank you. Give me the reference again, please.
It's page 7. And it's C subsection 5. And the language of the convention itself refers to the circumstances having ceased to exist. So it's an elimination of the risk, not a positive change in circumstances, but elimination of the risk.
Why do you summarise C5 as elimination of risk?
Because it says circumstances have ceased to exist. So those circumstances, that risk must have ceased to exist, and in a durable manner.
Right, so that parsing of C5 has been made, has it, in some existing decisions?
Yes, I'll take my lords and my lady to that now. So the first, the first case is Abdullah from the Court of Justice, which has then been referred to and applied in subsequent Court of Appeal decisions and by the Upper Tribunal. Again, I don't think the principles are in issue between the parties. If I could take my lords and my lady to Abdullah, and page 57 of the bundle, which should have paragraph 5 of the judgment, which again refers to the provision I've just referred my lords and my lady to. And if I could then take my lords and my lady to paragraph 65.
What page?
65 at page 64. It's paragraph 65 of the judgment, page 64 of the bundle. And paragraph 65 refers to the directive, which in the same way as the convention refers to the circumstances ceasing to exist. I could then take my lords and my lady to paragraph 69. The last sentence of paragraph 69, which again refers to those circumstances being remedied. So it's not that they've changed for the better, but they've been remedied.
The change in circumstances has remedied the reasons. I mean, is it your submission when you say that the risk had ceased to exist? That might be read as saying that there was no risk.
That's right.
That is your submission.
That is right. There's no risk
So
anymore.
a risk of any kind is not acceptable.
That's right. There's no risk. So it's got to be eliminated. And for that purpose, the possibility of internal relocation is not relevant, because internal relocation presupposes a risk. You only internally relocate if there is a risk in an area. So the risk has to be eliminated. And how one looks at that is then expanded upon at paragraph 70 to 73. And at paragraph 70, the last 3.5 lines in particular, in terms of the way in which the authorities and the country to which a person is to be returned operate the legal system for detection, prosecution, punishment of acts, constitution, persecution, and whether there would be access to such protection. That theme is expanded upon in paragraph 71. It's not just about the laws and the regulations in the country, it's about how they're applied. And then at paragraph 73, you have the term permanently eradicated. So it's a high threshold for the respondent to meet, because we're looking at ceasing refugee status in circumstances where it is recognised at some point in the past that there was a risk. And all of that has to be durable. If I could then take...
Sorry to interrupt. You said the possibility of internal relocation is not relevant, doesn't satisfy this. Is that somewhere in Abdullah, or is that some other authority you're going to take?
I don't think it's in Abdullah. It certainly is in the UNHCR letter, and we would say that it's obvious from the test, because if the test is that the risk has been eliminated, internal relocation presupposes a risk somewhere. And the test for internal relocation is not whether there would be a risk elsewhere, it's whether it's reasonable. So if the appellant was at risk, for example, in her home area, but she wouldn't be at risk in another area of Vietnam, if she was just applying for asylum and it was found that there was a risk to her in her home area, she could still be refused asylum on the basis that although there is a risk, you can relocate elsewhere, and that relocation in your circumstances would be reasonable. But when one is looking at ceasing refugee status, internal relocation is not relevant because it presupposes a risk somewhere, and cessation means that the risk has been eliminated. In any event, on the facts of this case, when one looks at the grant of asylum, the Secretary of State accepted in 2010 that internal relocation was not reasonable, appropriate, or would eliminate the risk. And we say that there hasn't been a change in circumstances since then that is positive for the Secretary of State. If anything, the appellant's vulnerability has increased because of the deterioration in her mental health.
Yes, but we're thinking at the moment about the function that is being carried out here. You appear to be saying, and you may be right, I'm just establishing what we're considering. You appear to be saying that somebody might, because of the circumstance in which they'd originally been granted refugee status, that it might be different for them, the removal of that status, than it would be for somebody who was applying for status on the same facts on the same day.
I think that must be the consequence of the submission, because if somebody is applying, they would be able to, that their claim could be defeated by the possibility of internal relocation.
So you can say in relation to person A, according to your submission, that they are refugees, even though person B on the same day on identical facts would not be a refugee. Is that the argument?
I'm not sure I follow that, my lord.
Yes. Well, you appear to be linking the cessation of refugee status firmly to the grounds on which it was granted some time ago.
Yes.
And so if it isn't established that those grounds no longer exist,
Yes.
then they remain a refugee.
Yes.
But if another person at the same moment as the cessation decision was being taken, put the same set of circumstances before the Secretary of State, the Secretary of State might be entitled to refuse refugee status on exactly the same material. Is that the analysis?
I suppose in theory that is possible, although of course every case is going to be very different on the facts, particularly because this is confined to the internal relocation issue. And internal relocation has to be reasonable in all the circumstances. But if we take the identical appellant who has been granted refugee status, say 5 years ago, and today we are looking at whether that refugee status should be ceased, I would submit that if the risk has not been eliminated, cessation cannot take place. But if she applied today and there was a possibility of internal relocation, and that relocation would be reasonable, then refugee status could be refused. So there is that difference. And I think that if one looks at the Upper Tribunal's recent decision in PS cessation, where it brings together all of the case law, summarizes it, on the facts of that case, that is what the Upper Tribunal did. It found that notwithstanding the improvement in circumstances in Zimbabwe, because there was a risk in a certain area, cessation was not appropriate. It didn't look at whether she could relocate elsewhere.
Thank you.
If I could take my lords and my lady then to Zimbabwe, which is, and the relevant paragraph is at 413 of the authorities bundle. And it's paragraph 24. And there one sees that what the tribunal should be looking at is not just country conditions, but personal circumstances as well. And it could be a combination of both that is relevant. It could be just one that is relevant. So personal circumstances might be exactly the same, but country conditions have changed to such an extent that cessation is appropriate, or it could be a combination of both, or it could be just the personal circumstances. For example, if somebody is fearful of persecution because of political opinion, that political opinion is completely changed and they might now be aligned to the ruling party. That could change the risk scenario completely. But one is looking at a combination of the factors. So simply focusing on the country conditions is not the right approach. One has to look at both the factual position for the person and the country conditions generally. The next case is MA Somalia, another Court of Appeal decision. And the relevant page is 419 of the authorities bundle. Paragraph 2, which continues over onto the next page. And again, the principles confirm that the relevant question is significant and non-temporary change in circumstances, so that the circumstances which cause the person to be a refugee have ceased to apply. And then at pages 436 to 437, this is paragraphs 53 to 54 of the same case. And in particular, towards the end of paragraph 53, the reference to the operation of an effective legal system for the detection, prosecution, and punishment of acts constituting persecution. That's quoting from Abdullah, which we've already seen that same paragraph. And at paragraph 54, the first two sentences in particular, that the test is designed to ensure that no action is taken to prejudice the status of a refugee until it is clear that the protection for him will be on a lasting basis. And then the latest case on cessation from the Upper Tribunal, PS cessation. And if I could take you to page 637 of the authorities bundle. Where the principles are summarized in 5 numbered paragraphs.
Yes.
And just before moving on to look at the rest of the case, if I could just take my lords and my lady to the decision of the Supreme Court in EM Eritrea, because I just wanted to add some meat to Roman numeral 5 in terms of the importance of the views of UNHCR. It's page 315 of the bundle. Paragraphs 71 to 74. The emphasis in the respondent submissions is to the last sentence of paragraph 74. The UNHCR material should form part of the overall examination of the particular circumstances of each of the appellant's cases, no more and no less. And that is right, but that must be read in the context of the preceding observations, because whereas that evidence has no special status, the views of UNHCR are deserving of respect because of the expertise of UNHCR and the experience. And therefore, whilst UNHCR's evidence intrinsically does not carry any more weight, it is deserving of and requires special consideration because it is inherently credible and needs to be properly addressed.
And this is what you say the FTT failed to do.
My lady, yes. If I could then take my lords and my lady back to PS at page 636 of the authorities bundle. Having set out the principles at paragraph 26, at paragraph 27, the tribunal sets out its approach in that appeal, applying those principles. And you will see that the focus is on the personal circumstances and relevant country background evidence at the time refugee status was granted, and then the circumstances, both personal and in relation to the background evidence, at the date on which the cessation decision is taken and the appeal is heard. And later on in the paragraph, the focus of the assessment must therefore be on both the 2008 and current circumstances of the appellant and Zimbabwe. And at paragraph 28, you then see that the tribunal begins by looking at the general situation in 2008 and then tracing the development of that situation through various country guidance decisions, which were all positive in terms of an improving situation. Well, I think the situation deteriorated and then improved in relation to Zimbabwe. So that whole history is traced. There is then detailed consideration of the evidence, in particular the medical evidence, because there was an Article 3 claim there as well. And then at paragraph 74, which is at 651 of the bundle, you have the reasoning and assessment on cessation. Again, the tribunal starts by looking at the circumstances in 2008. It takes that situation at its highest. It then traces the development of the law in relation to the country's situation in Zimbabwe, and concludes that there is a risk, despite the improvement in circumstances and the improvement in circumstances of the appellant in the sense, in favour of the Secretary of State. Her activities had subsided, she was a low-level member, and therefore the risk to her would have decreased because of the passage of time, the lack of activity. But it concludes, and this is at paragraphs 83 onwards, that although there might not be a risk to her in many parts of Zimbabwe now, in light of the improving conditions, there would be a risk to her in her home area. And it is on that basis that the tribunal finds that the cessation decision cannot be maintained. If I could then take my lords and my lady back to the FTT determination, it's page 81 of the core bundle, that the reasoning on cessation begins. Paragraph 45 at the bottom of that page. And then the consideration of the evidence begins at paragraph 48. The first difficulty with the reasoning is that there is no proper account taken, or any account taken, of the basis upon which status was granted to the appellant in 2010 by the Secretary of State, both the personal circumstances and the general country conditions. And that is an essential starting point that's clear from the authorities, that the judge simply jumps into the current circumstances. And it is important to look at the minute, which is a lengthy and detailed minute, of the reasons why the appellant was granted refugee status in the first place, And that minute is reproduced in the appellant supplementary bundle, beginning at page 89. It's a lengthy minute. I don't intend to take my lords and my lady through the whole minute. I would ask that entire minute is read, obviously, in due course. But if I could just take you to relevant parts of it. At page 93, paragraphs 50 to 52. Firstly, the consideration begins with the Secretary of State's representative saying that the account of the circumstances that led to the appellant leaving Vietnam don't need to be considered because they have been accepted in relation to the referral for as a victim of trafficking.
I'm adrift here. I think we all are.
We haven't got an appellant supplementary bundle.
We've got a respondent supplementary bundle.
I was sent that bundle, 4 minutes ago.
That was, this was chased up with the court yesterday by my junior, and we were told, I know that it was sent on Monday morning. I know the respondent has it, and we checked with the court yesterday. The court said they couldn't find it. Then it was sent again. It was confirmed that we now have it. It's been sent.
Describe this bundle. It's obviously got 89 pages. How many pages does it have in all?
It has
159.
And why is it being filed in the week of the appeal?
My lords and my lady, it was the difficulty, as you recited at the start, was the late respondent's notice and not knowing whether the respondent's notice would be admitted.
We're moving. I follow the argument that you've made so far, and I've been trying, while there have been gaps in the argument, to see where it's tethered in the grounds of appeal. I'm using the grounds of appeal document now rather than your skeleton argument. And ground 3, as drafted, is that the FTT judge failed to take proper account of the clear findings made by the Secretary of State in favour of the appellant when granting her refugee status.
Yes.
It was, for instance, expressly stated in granting refugee status that the appellant owed a debt to her traffickers.
That's right. And that's the minute.
So all the argument has hitherto been focused on the debt question because that's the only example that was given. But it appears, unless somewhere else within your grounds of appeal it's to be found, that this is a much wider structural complaint about the FTT decision.
That point is expanded upon in the skeleton. It's the same point, and there is extensive quotation from this document in the skeleton.
Right. Well, in that case, would it be helpful, as we're not blessed with the argument with the supplementary bundle itself, for you to situate us in the skeleton argument, and we'll make progress as best we can with that.
I do have 3 hard copies of the bundle. I can hand those up. I don't intend to take my lords, so I can take you through the skeleton.
We're not going to waste further time in that. We'll gratefully accept your offer and move forward. But you were going to situate us in the skeleton argument as well. So please do that. It's under 4 here, error of fact and failure to take account of the personal circumstances of the applicant, paragraph 20.
My lords and my lady, it would appear
24, is that what you're referring to?
There is actually a replacement skeleton which just updates that skeleton, which is in that bundle. So that obviously hasn't found its way to my lords and my lady either. I do apologise. This was, I was told, and I think we did confirm yesterday, that the solicitors did file it on Monday. I know that the respondent has it, and we did check again yesterday, specifically to check that all bundles have been received.
Now, this document, it's a 25-page document, replacing, you say, the document that you filed in September 2022,
That's right.
which was 15 pages
Yes.
and dated page 49.
The replacement's dated the 8th of October.
That's right. Again, my lords, the difficulty was that we were informed by the Civil Appeals Office that the respondent's notice would be, the issue with respect to the respondents would be decided on the papers.
No, we'll deal
So
with
we
it-
didn't
we'll
want to
deal
put
with
in-
this, the substance of it. This is now a 19-page document, and to what extent does this depart from the 15-page document that's been sitting there for the last year?
It doesn't really depart from it. It adds it adds references to this document in particular and to the country information, so that the skeleton is a more comprehensive document with respect to references to the relevant materials. So you'll see there's extensive, more extensive quotation from the minute, and there's more extensive quotation from the CPIN, which we hoped would make the
Well, at
task
the
of the
moment,
court easier.
let's stick with the point that you're making, which is that you're saying that you launched your attack on the FTT decision by saying that there's a difficulty at the beginning
Yes,
because there's no baseline consideration of what the baseline was on which status had
That's
originally
right.
been granted. And does this come in the your supplementary bundle, which I'm going to call the second supplementary bundle, at paragraph 22?
paragraph 22 of the skeleton, my lord.
Yes, I'm trying to link it to the grounds of appeal because you can't argue things that are not in your grounds of appeal.
Yes.
So where in this skeleton argument is the argument with regard to the grounds of appeal?
It's paragraph 22,
Right.
and also the test not being applied properly, and also I think if one goes to yeah, it's the test, because the ultimate test was an improvement in circumstances, the way that the FTT considered it, rather than a change in circumstances that was durable and eliminated the risk. So all of this goes to that, because that's the overall test.
Yeah, but I'm sorry. I mean, you know that we can't have shape-shifting arguments at this stage of a procedure that's been going on for such a long time. But I'm not labelling your arguments that, but I'm just saying if they are, we have a difficulty with them. But ground one, as I understood it, and as I read the document, even in its latest emanation, it was the wrong test
Yes.
argument, which is to do with it being regarded as a change of circumstances rather than a permanent eradication, as you would put it.
That's right.
Right, that's what ground one
But in order
amounted
to,
to.
my
Ground
lord,
four, as expressed in this skeleton argument in your previous one, is to do with, largely to do with the debt.
that's right, and that links on.
Where does the no proper account taken of the basis upon which status originally granted an essential starting point? Where does that essential starting point argument come in any of your presentations?
The mistake of fact relates to that, because that is the failure to take account of the findings in 2010. Had those findings been taken into account, the FTT would have understood,
But in
would have
order to, I
realised
mean,
that.
if it's not to be an empty exam point, what is the change of circumstances apart from the debt upon which you're going to rely? I mean,
Well, we say there is no change. There is no material change. It's the Secretary of State's that's saying that there is a material change and that therefore cessation can take place. We say that there hasn't been a change, and the way that that change needs to be considered is by assessing it to the circumstances at the date that asylum was granted, and that the incorrect test involves a failure to look at that. So one can look at the incorrect test in a very narrow way by just focusing on 62 and 63 and what the judge has said. But in order to give some substance to that argument, one has to look at, in my submission, the approach that the authorities say should be taken and the approach that the judge actually took, and then the consequences for his determination. Because, of course, part of this also is that the assessment of the background evidence was flawed. And it is important to compare in that context as well, because the background evidence shows that in 2021, the CPIN itself was saying that there continues to be a risk, but that actually the points relied upon by the judge were already considered by the Secretary of State in 2010, and the Secretary of State found that notwithstanding efforts, refugee status should be granted.
Right. So, situating myself in these documents, paragraphs 9 and 10 in both documents, those having been expanded
Yes.
in your later one, but only somewhat. Is that the?
Yes.
Is that where we find it?
That is, my lord, and as I said, it's an overall submission in terms of cessation. There are substratas to it, and those points have been numbered out from 1 to 6. But essentially, the appellant's submission is that the judge failed to consider the cessation issue properly, and these are all the errors. In order for the court to assess that, it is important to look at that minute.
So that's the first aspect of what you describe as difficulties.
Yes. Can I take my lord to the minute?
Where are we looking? Where are we looking here? It's in this new.
It's in the
document.
supplementary bundle, my lord.
Second supplementary bundle.
The second supplementary bundle, yes, and it begins at page 89. And I wanted to take my lords and my lady to paragraphs 50 to 52 first of all, which is at 93.
Can I just say, this isn't the best of photocopies. We're grateful indeed for the hard copies you provided this morning, but they are somewhat faint.
I apologise, my lady. It might be that that's a reflection of the state of the original, because it's an old document. I can certainly email across. My version is tolerable. I can email that across later if that helps. I apologise for that. 50 to 52, you will see the initial consideration of the trafficking issue, and the Secretary of State notes that the circumstances that led to the appellant arriving here will not be revisited because there is no evidence to deviate from that finding, and that finding was made on a higher standard than the Refugee Convention standard. But at 51, in relation to the specific assertion by the appellant that her traffickers were looking for her, the Secretary of State's position at 52 is that that part of the claim remains unsubstantiated and will be considered using the relevant principles. Those principles are then considered to paragraph 57, and after paragraph 57 you have in bold, the general credibility of the applicant has been established. And then at paragraph 60, under the subheading conclusion, the Secretary of State rejects the appellant's assertions about a fear from her ex-husband, but accepts the trafficking account and accepts that agents have visited her family home in search of her. That is then, well then at 61 you have the consideration beginning as to whether there would, in light of those factual findings, be a risk. At 62, the Secretary of State reiterates that it is accepted that the traffickers have returned to her home address in search of her as she is bound by debt to them. In light of this, it is considered that there is a real risk that the claimant may be pursued by her traffickers and that her fear in this regard is well founded. Then at 63, consideration is given to whether sufficiency of protection exists. Without going through this in detail, what it essentially shows is that there were laws at that time prohibiting most forms of trafficking in persons. The government was making efforts to combat the trafficking problem, but the government does not fully comply with the minimum standards. And at 64, it is considered that there are efforts being made by the Vietnamese authorities, but the evidence suggests that the Vietnamese government does not yet focus adequately on what it needs to do. At 65, it is noted that there are shelters available for victims of trafficking. And then at 66, it is considered that the claimant would not be able to return to her home area since it is accepted there are agents searching for her there, which would raise the risk of the claimant being re-trafficked. And then the decision is to grant refugee status. So that context in the appellant's submission was crucial to an assessment by the FTT as to whether there had been a significant and durable change in circumstances that eliminated the risk. But it is entirely absent from the determination. The failure to look at that led to the error of fact. The error of fact being that there was...
Is this your second
Yes.
difficulty?
The second difficulty
Yes.
with the determination. That's right, my lord. And that issue is considered by the FTT at paragraph 50 of its determination, which is 82 of the core bundle. And it is important to look at the precise terms in which the judge has made his findings. There is no credible evidence in the appellant's case that she owes anybody any debts. That is clearly not correct because it was accepted by the Secretary of State that she did owe debts and was being pursued for it. Other than a mention in her statement attached to her solicitor's representations in 2016, in which she speaks of her traffickers visiting her mother's property, there is no other evidence of any visits nor any chasing of debt that she had accrued in Vietnam. Well, that is clearly not correct because in 2010, the appellant had put that case forward and it was accepted. The appellant's daughters remained behind in Vietnam until 2011 and experienced no issues or visits from anybody chasing their mother's debts. And it is not credible that the appellant would be at risk now, having left over 15 years ago. I do not find it credible that the appellant has any outstanding debt in Vietnam. Well, the daughters were there when she was granted asylum. The mother was there, the sister was there, the Secretary of State was aware of that. The difficulty with the FTT's determination is it is reasoned entirely absent any consideration of the note from 2010 where the Secretary of State sets out the claim made by the appellant and expressly and repeatedly accepts that there is a debt owed, that she is being chased for it, and that therefore there is a risk.
Right. You say the Secretary of State accepted this in relation to the various findings at paragraph 50.
Yeah.
Is that accepted this in 2010?
In 2010, if one looks at the decision,
No, I'm just asking what you mean by what you were saying.
I think my reading of the decision is that the Secretary of State's position in 2019, when this claim was refused, is that it's not credible that they would still be looking for
Yes,
you.
exactly.
Yes.
Well, one
That's
reading
different.
of paragraph 50 might be thought to be that that's what the FTT judge is saying and accepting. Are you putting a different interpretation on that?
Absolutely, my lord, because when one looks at the reasoning, it's wrong. There are mistakes there. The judge says that the first evidence of this was 2016. He says that there is no credible evidence.
Yes,
that
but
she
I mean,
owes
bearing in
anybody
mind
any
that
debts.
bearing in mind that to revert. We're not marking an exam paper here. We're trying to see what the gist of this decision is. And it seems to me, at least on the several readings I've so far given this, that the gist of what the judge is saying is that there's no live debt that is likely to put the appellant in peril because of the passage of time. Now, I'm just giving you the opportunity to say, no, that's not what that says at all.
No, that isn't what it says at all. Because of the precursor to it, my lord. If one looks at the reasoning that leads up to that final sentence, it's on the basis that your claim is incredible. You've not said this before. He says in terms that there is no debt, no credible evidence in the appellant's case that she owes anybody any debts. Not that that debt has been paid. And if he had started at the correct starting point, the judge should have been saying, well, in 2010 you did owe a debt, and he should have been asking himself, 15 years later, it might be that I think that that debt might be forgotten. It might be that I think the traffickers wouldn't now pursue it, but he should reason that and explain why he thinks that in the context of there being an accepted risk in 2010 and traffickers not being known to forget debts. And of course, upon her return there, it might be that there is no pursuing of that debt because the traffickers know she is not there. But upon return, is there a risk that her presence would be discovered and that debt then pursued? And if he's saying that there is no debt because 15 years have passed, well, who paid the debt? None of that has been engaged with. And when one reads this passage as a whole, in my submission, the reality is that the judge has failed to appreciate that in 2010, the Secretary of State accepted that there was a debt. And what he should have done is then grappled with the passage of time and addressed the issue. There was a debt. Has that debt been paid? Or am I satisfied that upon return, there is no risk to the low standard that the traffickers would resume their pursuit of that debt? That isn't addressed here.
But is that wholly correct? If one just looks at the sentence in paragraph 50, it's the final sentence at the end of my hard copy page.
Yes.
The appellant's daughters remained behind in Vietnam until 2011 and experienced no issues or visits from anybody chasing their mother's debt. And it is not credible that the appellant would be at risk now, having left over 15 years ago. So the judge is addressing that very much proximate in time. The debt is linked to the year of 2011, referring to the decision in 2010, so there is an approximate.
My lady, if the judge had said that I accept that in 2010 there was a debt and the traffickers were chasing it, but in 2011 the traffickers had forgotten about it, or it had been paid, or had reasoned something along those lines, that could be an acceptable assessment of the overall situation, the situation in 2010 and whether that situation has changed. But to simply say that the daughters never faced any problems, and of course that is not correct, because the daughters were living with the mother in Vietnam when the appellant left, and it is accepted by the Secretary of State in 2010 that the mother was facing difficulties. In fact, I think the account was that she was facing such difficulties that she had to move from her house. So the daughters did face those difficulties because they were there. It's just that they didn't give the account of it. They were young and the mother was facing it. So my difficulty with this whole passage is there is nothing there that suggests that the judge has taken into account that in 2010 there was a positive finding on this. I accept that it would have been open to the judge to say, I accept in 2010 there was a debt owed, but now in 2021, that debt must have been repaid because nobody's chasing it, or that there's a passage of 15 years and therefore I find that there would be no risk of the traffickers chasing that debt. But one would expect that reasoning to be pinned on some background evidence as to what sort of conduct one would expect from traffickers. It's not in the nature, in my submission, of traffickers and criminals generally to forget debt. And somebody that's been persecuted in the way that the appellant has, if one is looking at the low standard of risk in an asylum claim, in my submission, it would be difficult to say that the passage of time on its own is sufficient to say that there is now no risk, no real risk of the traffickers wanting to get that debt back from her. She doesn't have to show that she will be pursued immediately upon return. Of course, that wouldn't happen because nobody would know that she'd returned on the moment she arrives in Vietnam. But of course, with the passage of time, her presence might become known. And it's not that she has to establish on a balance of probabilities that it is more likely that they will come. It's simply a risk. That's a low standard. And we have the recent Court of Appeal decision in MAH Egypt, which is in the bundle. I'm not going to take my lords and my lady to it, but that sets out the whole history of the low standard test and why the standard is so low. And we're looking at risk. And in my submission, when you've got a situation where traffickers are pursuing a person for debt and that person has fled from the traffickers, it would be a brave judge that would say that the passage of 15 years is sufficient to remove that threat just because of the passage of time with the debt not having been paid. But the difficulty in my submission is that the judge doesn't really grapple with what happened in 2010.
Yeah, that's the essence of your
That's
point,
yes,
isn't
and
it?
my submission is that it seems as though he hasn't appreciated the finding of fact in 2010 that a debt was owed.
Can I just say, for the record, that thanks to Mr. Hingora, finally, the electronic versions of the documents you kindly handed up a moment ago have arrived with our clerks, and so in the time after the hearing, we'll be able to have them as an electronic.
I do apologise. As I say,
There's
we were
no
concerned that
need to
it might not have reached my lords and my lady, and we did chase this yesterday afternoon, and we were assured by the court that they had been sent, but obviously something has gone wrong, and it is very last minute. All
Yes.
I can do is apologise, my lord.
Well, we won't spend more time on that. Now, has that finished with the second difficulty?
That has. I can move on to.
Can I just ask,
Yeah.
presumably the first tier tribunal judge had this document?
Yes, it was in the respondent's bundle.
Yes.
The respondent's bundle.
That's right. So the Secretary of State herself had provided it.
Yes, so when the judge said at paragraph 20, I've carefully considered all the evidence, but I've not specifically mentioned a document, certain evidence, etc., doesn't mean I haven't considered it. That encompasses everything that he had.
My lord, yes, but of course that isn't a get out of jail free card for any judge. It is what he said, and I think it's probably the sort of phraseology that every judge puts into his decision at the FTT, because there are so many documents. But of course, important documents, and the cases are settled on this, important evidence, one would expect the judge to refer to, consider and explain.
Right.
And the difficulty is that the reasoning suggests that this hasn't been looked at.
Fine. Well, I think we have your submission.
I'm grateful. The next point is the failure to take account of UNHCR's concerns, and that,
Can we call this the third difficulty?
that's right, yes. Now, I accept that at paragraph 44, the judge sets out in summary UNHCR's concerns, so it's not that he hasn't considered them. He's considered them and also set them out in the determination.
Yes.
But in his assessment of the evidence and his assessment of the cessation issue, he does not give any substantive consideration to those concerns. So considering those concerns, there's two issues we say that the judge erred on in relation to UNHCR. First, he didn't engage substantively with the concerns. And secondly, he didn't give them the considerable importance that the cases say he should have, and in particular, the detailed passage from the Supreme Court decision in EM, I think it was EM Kosovo, EM Eritrea. So at paragraph 48, he simply says, UNHCR's views are to be carefully considered, but carry no special weight or status simply by virtue of their authorship. We say that that in principle is not entirely correct. It doesn't reflect the considerable importance that PS says UNHCR's views should be given in the summary of the principles, and it also does not reflect what was said by the Supreme Court in EM Eritrea. He then, at 61, next addresses the UNHCR letter and simply says the CPIN is more up to date than the UNHCR letter, and the country expert report provided by the appellant in the latest addendum country expert report does not make reference to the CPIN. So the only thing said about the UNHCR letter is that I prefer the CPIN because it's more up to date. Now, the UNHCR letter is dated January 2018. The CPIN is dated April 2020. But the source materials being referred to in the CPIN are all dated 2019. And I've put some more detail in the skeleton in relation to this. Let's take, my lords, to the relevant paragraph. You'll just bear with me. So paragraph 15 and 16 of the skeleton, which is pages 55 and 56 of the bundle. And so when one actually looks at the CPIN, although it's dated 2020, the material is from 2019. And therefore, the distance between the UNHCR letter and the CPIN is not so great, particularly when one is looking for a durable change in circumstances. And in any event, it's not about the timing, it's about the substance of UNHCR's concerns and engaging with them. There is no engagement with those concerns. And the key concern that UNHCR expressed, which is set out at paragraph 17 of the skeleton, is that there had been positive developments, and that was the situation in 2010 as well. It's not that Vietnam is not doing anything. The concern was that the minimum standard of protection had not been met, and that remained the case at the date of the FTT's determination. And UNHCR also urged the SSHD to undertake a thorough assessment of available support networks, without which returnees may be at risk of serious harm. And these concerns were not addressed, particularly the concern about there being positive developments, but the minimum standards still not being met. And then this is relevant to the UNHCR point. It's set out there in the skeleton, but it also overlaps into the fourth criticism, which is that there has been no proper assessment of the background evidence. And it'll be easy, my lords and my lady, I hope, to just look at the skeleton, because I've set out the passages that the appellant would rely upon and point to with respect to a full and proper, thorough assessment of the actual CPIN that was before the FTT. And I'll just emphasize a few of them.
Is this paragraph 18?
Paragraph 18. So the quotations there are from the CPIN that was before the FTT.
Right. Is this point 4 selectivity?
It is, but it also overlaps with 3, because what it...
No, it may overlap with 3, but we do have to keep some sort of
Yes.
track of where we're going. Is this a fourth and overlapping point?
Yes.
That the use of the CPIN, you say, was selective?
Was selective.
Paragraph 18, skeleton argument. Yes.
So if one just looks at paragraph 18 and the extracts there, the full CPIN is in the respondent supplementary bundle. Trafficking in human beings is illegal, but it remains a serious problem and is increasing. And then the definition does not fully correspond with the internationally accepted definition of trafficking. Circumstances virtually identical to the situation in 2010. 2.4.6, there is, however, some evidence that returnees may be at risk of re-trafficking or reprisals if they have outstanding debts. It is unlikely that person would be re-trafficked once returned to Vietnam, but a person's vulnerability may affect the likelihood. Each case will need to be considered on its merits. So it's not even an eradication. It's unlikely that they would be re-trafficked, but one cannot say that they won't be. But there are risk factors that need to be considered. And the three risk factors that are relevant to the appellant are at 2.4.8, an outstanding debt to the traffickers, no other support network to assist them, and material and financial deprivation. And bearing in mind that the mother that is there is now in her 90s, so the support that can be expected from her is going to be is very limited. And also the third point, mental health conditions, which may have been caused by experiences of abuse when originally trafficked. These are factors that are clearly relevant to whether there would be an ongoing risk. And then at 2.5.2, current evidence shows that the situation for trafficking victims in Vietnam remains largely the same as the 2010 US State Department Trafficking in Persons report, with the government still not meeting the minimum standards for an elimination of trafficking, but making significant efforts to do so. But this is the policy part of the CPIN. So the dispute between the parties as to whether the judge erred in conflating the two parts, this is the policy part. So this is the Secretary of State's own digestion of the country information material and her policy, that the situation is the same as it was in 2010. 2.5.5. Whilst legislation exists and prosecutions do occur, the government does not systematically refer victims to protective services, as the government's definition of trafficking does not fully correspond with the internationally accepted definition. Again, a concern that was highlighted in 2010 and remains. At 6.1.3, the government of Vietnam does not fully meet the minimum standards for the elimination of trafficking, but is making significant efforts to do so, same as 2010. The government did not demonstrate overall increasing efforts compared to the previous reporting period. 6.3.1, the government decreased efforts to protect victims. 6.3.2, complicit Vietnamese officials, primarily at commune and village levels, facilitate trafficking or exploit victims by taking...
Well, there's quite a long series of passages. Do you want to just refer us to the ones you particularly want us to light on without having to read them
I am
out?
trying to do that, my lord, so I'm skipping through. There's only a few more left. You'll see that the whole passage is significant. All of this is not considered in the report. 6.4.1, for the seventh consecutive year...
Right, you don't have to read it out if you just tell us what one you want us to read. Yes?
6.5.1, no prosecutions.
Yes.
6.5.2,
Yes.
7.1.4, this is the NGO Hagar that the FTT placed significant weight on. Itself said that victims are eligible support, but in reality they do not receive much. 8.1.1, the 2019 report saying that victims of trafficking were vulnerable to re-trafficking. And 8.1.2 and 8.1.4, again, talking about the vulnerability and risk of re-trafficking that continues to exist in the limited support. So this gives you a flavour of the overall content of the CPIN. And when one contrasts that with the judge's assessment of the CPIN, it is entirely focused in my submission on what has been said by Hagar. Hagar is an NGO. It has limited experience by definition. Paragraph 55 of the FTT determination, the judge himself says that Hagar said that they are able to support 60 people at a time. So that's a tiny minority of the people that are at risk and are identified as victims of trafficking, that is set out in the CPIN itself. And the focus is all on the support that would be available from an NGO. At 59, when referring to what Hagar said about the risk of re-trafficking, notwithstanding that that needs to be considered in the overall context of the content of the CPIN, Hagar simply said that they had not seen any, so they were not aware of any. And the appellant's submission is that this consideration of the background evidence is entirely inadequate in the context of a cessation claim in relation to a person that has been accepted to be a victim of trafficking. And of course, in an asylum claim, one has the requirements of anxious scrutiny and the lower standard of proof. The next point, my lord, is the findings in Nguyen, the 2015 case.
This is fifth
Yes.
point.
And the straightforward point on that is that it's not a country guidance case. And when one actually looks at the paragraph that is referred to, I'll just find that in the authorities bundle. It's at 577 of the authorities bundle. The relevant paragraph is paragraph 52. Which begins at page 589 of the bundle. In my submission, it's very clear that that paragraph is assessing that appeal on its particular facts and on the evidence that was before the tribunal in relation to the background circumstances. It is not in any way a finding that is of general application.
This is 49 in the FTT decision, isn't it?
That's right. The way the judge has considered that case suggests that he felt the upper tribunal had made a general finding. But in my submission, it clearly hasn't. It's a finding on the facts. It's not been reported for country guidance. The head note says nothing about the general risk to somebody returned to Vietnam having been a victim of trafficking. Then I can move on to the final point on cessation, which is that the test applied at 62 and 63 of the FTT determination is clearly the wrong test, notwithstanding that the correct test has been set out earlier in the determination. The finding...
I'm so sorry, I was writing something else down. Could you just repeat what you...
62 and 63, the test that's actually been applied by the judge is the wrong test, notwithstanding that he sets out references to the correct body of case law and test earlier in the determination. We've already seen from the cases and from the convention itself that the test is a significant and durable change in circumstances that means that the risk has essentially ceased to exist. Various formulations: cease to exist, permanently eradicated, circumstances ceasing to apply, but it's a cessation of the risk. What the judge concludes at 62 and 63 is that the situation has improved. There is legislation in place prohibiting trafficking. Well, that was the case in 2010. There are shelters and support organisations in place. That was the case in 2010. But then the conclusion at 63 is the respondent is successful in demonstrating that there has been a significant and non-temporary change in circumstances in which the appellant was recognised to be a refugee. But the essential final part of that test is omitted, which is that that significant and non-temporary change in circumstances means that the risk has ceased to exist.
Well, I understand linguistically the point that you're making, but we'd have to conclude, wouldn't we, that the judge had, that in 3 pages, the judge had forgotten the test that he was meant to be applying.
Yes, but in the context of the importance of this, the anxious scrutiny required, the failure to state the essential element of the test is important, particularly because of the other failings. And when one looks at his reasoning between paragraphs 48 and 61, the focus is not on the parts of the CPIN and the questions that should be asked. And again, I refer, my lords and my lady, back to the passages from the authorities about the questions that need to be asked. How is law being implemented? Is it accessible? What is law enforcement like? There might be laws there, but how are they being applied? Those questions have not been addressed. What he is doing is addressing the availability of support primarily, and the fact that there is legislation in place that prevents trafficking. He doesn't actually address the essential question, which is how effective is that legislation? How accessible is the protection? And because of that failure, one can, in my submission, readily read the absence of the crucial term in paragraph 63 as showing that the judge did not take account of the correct test when he actually reached his conclusion.
So, paragraph 46 of the decision,
Yes.
the second sentence, beginning thus the relevant question, that's an entirely accurate recitation of the appropriate test.
It is. It is. I accept
You
that.
get it from Abdullah or MA or wherever.
Yes.
And
But that isn't replicated at 63. And it's not that it's a, if he'd forgotten durable or non-temporary or significant, one could say that the reasoning shows that the change is significant. The reasoning shows that the changes are non-temporary. But the crucial part of the test is omitted, which is that the risk should cease to exist. And one cannot take, in my submission, from the reasoning or anything said at 62 and 63, anything that suggests that he has applied his mind to whether the risk has ceased to exist, as opposed to whether the circumstances are better and she would have support.
Right, we have the argument.
Those are my submissions in relation to the cessation point. I take on board what my lord said this morning about Article 3. The appellant's case on that is fairly straightforward, in that before the tribunal, she produced evidence showing that there is serious mental health problems she suffers from, plus the HIV issue. The judge accepted.
You say that gets her to stage 1 of the Article 3.
Yes, and we say that the judge accepted she surpassed stage 1 because he then goes on, he says in his own determination, the key issue is whether treatment is available and accessible, and that is stage 2. And we say that the clear error is that he placed the burden on the appellant as opposed to the Secretary of State. That's clear from 80. And he also failed entirely to consider the issue of risk with respect to the HIV infection. Those are significant failures, particularly in the context of the evidential picture before the FTT, which was that the appellant had put forward expert evidence, but there was no evidence whatsoever from the respondent, and there's no relevant CPIN or guidance note.
As to stage 1, are you, is this paragraph 75 of the decision?
Yes, 75
to 70.
Yes, and then at 77, so having quoted from AM Zimbabwe and Papashvili, the relevant test, he says at 77, what must be looked at is whether the appellant could access medical treatment in Vietnam. If the appellant cannot access medical treatment, then there is a substantial risk of relapse which will be reasonably quick. So he himself is going on to the second stage. He hasn't expressed himself very clearly, I accept that. There is no clear assessment of the first stage, but it's, in my submission, clear from the way that he sets out the evidence, accepts that evidence completely at 75.
Right. And you say that 78 to 80 shows that he put the appellant to proof.
That's right, which is not the correct approach. Now, I could take you through the authorities and the relevant evidence now, but bearing in mind your indication this morning, I wonder whether it would be a more efficient use of time if I responded to anything, if necessary. There is quite a lot of material, particularly with respect to the mental health report, because the extract in the FTT's determination is a very short extract from what is a very lengthy report that sets out all of the difficulties.
I think it's, I will ask my lady, my lord, for their view of this, of course, but bearing in mind that Mr. Hansen, I think, is going to try to get a challenge to the stage 1 finding on its feet, it doesn't really make sense for you to be answering piecemeal, and I therefore think that it may be. It may be better if we move to Mr. Hansen now, if that really concludes your submissions, but appreciating that you're reserving your position entirely in relation to what you've called ground 2. So, as a compulsive list maker, I'm now clear that we're dealing with ground 1 under 6 subheadings, and ground 2 you've summarised in a global form without elaborating at this point.
That's right.
Is there anything else that you'd like to
no, unless there's anything further that I can assist, I'm very grateful.
Thank you very much.
No, very helpful. Thank you very much. Yes, Mr. Hansen.
My lords, my lady, can I begin with the point of principle that Lord Justice Nugee identified in his permission grant? Because my primary submission is that the answer to the question that he posed is yes, it is incumbent upon an applicant to adduce prima facie evidence as to the availability and or accessibility of medical treatment in the receiving state.
Right, just let's just write this down. Your submission is it is incumbent on applicant
in an Article 3 medical case.
In Article 3 case.
To reduce prima facie evidence as to the availability / accessibility of medical treatment in the receiving state before any procedural obligation or evidential burden can shift to the Secretary of State. That's the core submission on the point of principle.
Right.
In a sense,
just a moment, sorry. Incumbent upon the appellant in Article 3 medical case to produce prima facie evidence of the lack of availability of medical facilities before the burden shifts.
Yes. I bracket availability and accessibility together.
Yes, you did.
And that is a pure point of legal principle that the court, it seems to me, will have to resolve in the course of this appeal, regardless of the facts and the evidence. Can I begin by addressing you on that core point of principle, and then deal with the other issues, I hope, very briefly. That is the central concern on the part of the Secretary of State, that this law should not take a wrong turn in relation
Right.
to
Well,
that.
where was this point made before the respondent's notice?
Well, in my respectful submission, it depends how you construe the decision of the FTT.
Yes, but I mean, I just want to understand whether, in a sense, you're launching on your respondent's notice. Or whether you're going to say, this is a point that was made in the decision letter, or this was a point that was made at the FTT or the UT.
Yes. I'm saying this is a freestanding point, separate from the respondent's notice, and it was part of the course of argument below. Right. And I say, Lord Justice Nugee, in fact, approaches the decision below, and by below I mean the FTT, that's the focus of our consideration, on the basis that the arguable error that the judge has made is in casting that burden on the appellant. And my primary submission is that is what he did, but it wasn't an error. Can I proceed in that way then, by developing the submissions on the point of principle, and then come lastly to the respondent's notice? And as I say, I think I can deal with that actually very succinctly without adding much to the course of argument in this court. So before I go to the authorities, can I set out 5 core principles that we submit are vouched for by the authorities in this context, Article 3 medical cases? The starting point I submit, and I do submit this is an uncontroversial first principle, is that where a foreign national resists removal on Article 3 medical grounds, the overall legal burden is on him or her to show that Article 3 would be infringed. And he or she does so, but again, this is uncontroversial, by showing a real risk of being subjected to one or either of the prescribed kinds of deterioration referenced in Paposhvili, i.e. a serious, rapid and irreversible decline in their state of health resulting in intense suffering, or B, substantial reduction in their life expectancy. And in this context, we're concerned with Article 3 in its substantive dimension, and what is essentially a negative obligation not to expose persons to the risk of Article 3 ill treatment. That's my principle 1. Principle 2, an applicant making an Article 3 medical claim or advancing an Article 3 medical claim.
You're reading and we're writing. So are we going to be helped by anchoring ourselves in your skeleton argument?
This is a speaking note that I'm looking at.
Yes, but where is this in your skeleton argument?
Well, my skeleton argument develops these points primarily by reference to the authorities, but I thought it would be helpful to extract.
I'm not saying it isn't helpful, but I want to be sure that this is not simply new argument off the cuff.
Well,
and also, I don't want to have to write down everything you're saying if you've actually said it already in writing or something like it, because you have a skeleton argument which runs 25 pages, so I'd expect
Yes.
that it features somewhere in it.
As I say, the skeleton argument develops the points primarily by reference to the authorities.
Yes.
And I've tried to, I hope helpfully, extract the principles that I say are vouched for by the authorities, to which I'm going to turn in a moment. But in my submission, there are no surprises. The thrust of a clear thrust of our argument, beginning at para 48, and then the submissions on Article 3 that begin at 89, is to the effect of my submission. If one looks at 89, I say the law in respect of Article 3 is it is respectfully submitted settled. The initial burden or threshold test requires the applicant to establish a prima facie case which, if not answered, would establish a breach. This is stage 1. The claim can proceed no further if the applicant fails at stage 1, etc. As I say, I say I'm developing the points made in my skeleton. At 97, I identified the point raised by Lord Justice Nugee, and I set out our arguments on the proper construction of AM Zimbabwe. And I say in clear terms, the appellant is wrong in this appeal to suggest that the Supreme Court was saying at 33, it is solely the responsibility of the Secretary of State to present evidence as to availability. It is clear for the burden to be even to be engaged, the Article 3 threshold requires crossing, which of itself requires the provision of prima facie evidence addressing issues of availability and inaccessibility.
Right. Now, you've made your first point of your 5.
Yes. My second point is this. An applicant making an Article 3 medical claim must make out a prima facie case before any evidential burden can shift. That means a case which, if not countered, would establish an infringement. An applicant needs to produce evidence which, if not countered, would win the appeal. It is a demanding threshold, as all the authorities make clear. And the evidence in my submission needs to address all limbs of the Papashvili test, including causation, those words on account of, and availability/accessibility. And importantly, there is no carve-out in relation to availability/accessibility of medical treatment in the receiving state. So that obligation to make a prima facie case covers all limbs of Papashvili with no carve-out for issues as to availability/accessibility. That's my second principle. My third principle is this: in this Article 3 medical context, the Papashvili standard is, to use the language of the court, a comprehensive standard, and we'll look at Papashvili in a moment. So an applicant either meets that standard or fails. There are no further exceptions or leeway. It is a comprehensive standard. Fourthly, the decision maker, whether it be the Secretary of State or, more relevantly for present purposes, the Tribunal, cannot read in such evidence where it doesn't exist. Fifthly, where such evidence is adduced, and only where it is adduced, it is then for the returning state to dispel any serious doubts raised by it, and the procedural obligations in Papashvili at paras 187 to 191 come into play at that stage, but not before. Those are my 5 key principles, and I will make them good by reference to the authorities. But before I do, can I pose a simple example that in my respectful submission lays bare the fallacy in the appellant's argument? Take the case of a seriously ill person with a condition that, if left untreated, will rapidly deteriorate to Paposhvili standards. Assume that person is being removed to mainland Europe, France, Germany, Sweden, any other ECHR signatory, or any other country with a developed health system. The US, Japan are obvious examples. On the appellant's case, the mere fact of their serious health condition and its likely progression, if left untreated, would give rise to a prima facie Article 3 breach. And the onus would then shift, and the Secretary of State would be incumbent on the Secretary of State to say, hey, there are facilities in City X, City Y, it's accessible, it's free at the point of entry, whatever the point is. But in my submission, the appellant's position is simply cannot be right, taking that simple example. To raise a prima facie case in those circumstances, an applicant would surely have to adduce some credible evidence to explain why they wouldn't be able to access effective treatment
Well, I
in the
might have thought
receiving
that somebody in
state.
those circumstances raising an Article 3 case would not get very far,
Yeah.
and that one wouldn't be concerned about stage 1 and stage 2 and so forth, because it would be patently
I agree.
patently an empty case.
But
So
it
why does it
illustrates-
shed light on cases where it might matter?
Well, it sheds light on cases where it might matter, because it suggests clearly in my submission that part of that initial onus encompasses the issue of availability or accessibility of medical treatment in the receiving state. I mean, let me give another example that I say goes to the same point, but again illustrates it in a different way. Take someone again with a very serious condition, liable to relapse very quickly with dire consequences if untreated, but where they can be effectively treated with a simple over-the-counter medicine like aspirin that is generally readily available at little or no cost. Again, to make out a prima facie case, that appellant would have to explain why they wouldn't be able to access this ordinarily readily available over-the-counter medicine in the returning state. I mean, they're simple examples.
It's not much of a burden on the Secretary of State, is it? You can buy aspirin in Cambodia, wherever it is, full stop. I mean, I don't want to sort of cut you short. I think you may find yourself hoist by your own petard if you start engaging in analogies and examples.
Well, but the examples I give are simple examples to show that the initial burden encompasses all aspects of the Paposhvili test. That's the simple headline point.
Right.
And there's no carve out. So the answer to the point of principle, regardless of the court's disposition of the appeal generally, is a clear one in my respectful submission.
Well, we've understood the analogies.
Can I then take you to the authorities? And I'm going to focus, obviously, primarily on Paposhvili, AM Zimbabwe in the Supreme Court, and Safran. But before I go to those cases, can I briefly touch on AM Zimbabwe in the Court of Appeal? Because certain passages in Lord Justice Sale's judgment were commended by the Supreme Court. And so I just want to show you those, because you can't, they're not repeated, the text is not repeated in the Supreme Court's judgment. The AM Zimbabwe is in the authorities bundle, hard copy 855, so that would be electronic 856. Can I go to paragraph 16? This was the paragraph that Lord Wilson references as obviously right. And he sets out the position there in relation to the overall legal burden.
Sorry, can I apologise? I had a later authority bundle, but it is missing pages 832 to 876.
Ah,
If anyone's got, if your junior has it and would be kind enough to hand it up, that would be enormously helpful. Thank you.
832. 832 to
76.
Thank you.
Thank you very much indeed.
Paragraph 16 is at page 861 in the hard copy, 862 in the electronic. And then the other two paragraphs that I want to refer to, because they'll shed light, valuable light on my submissions in relation to Paposhvili, are paragraphs 25 and 26, or 25 to 27. You'll see at the beginning of para 25, he says, Grand Chamber applied those principles. It found the applicant raised a case regarding difficulties in relation to treatment of his illness if he were returned to Georgia, which was not without some credibility, i.e. which raised a prima facie case under Article 3. So the point he's making, and it's borne out by Paposhvili, is there was evidence in that case at stage 1, if you want to call it that dealt with difficulties over treatment in the returning state. And that was the evidence which raised a prima facie case, which shifted the obligation to the Secretary of State.
Right. Does it amount to this, that the prima facie, when we're talking about a prima facie case, it has to be a credible prima facie case, if it's necessary to add the word credible?
It has to be a credible prima facie case, and but importantly, a case which, if not countered, establishes the infringement. That's what the Supreme Court make that clear in AM Zimbabwe, right. In the Supreme Court.
So if this is going to avail you, you're going to have to persuade us, if you're allowed to run the argument, that is not so in the present case.
Well,
but this is a sort of, it's a Paposhvili case or an aspirin case or a European deportation case, and it should be treated in the same way. That's where this is leading.
Well, this is leading to the point that the judge was right in casting this initial burden on the appellant. That's the gravamen of my learned friend's criticism of the FDT's judgment on this issue. Those passages that he just took you to briefly, saying that's wrongly casting the burden on the appellant. And I say that burden was on the appellant and it wasn't discharged on the material before the court. And that's what the FDT judge said in terms at paragraph 80 in the decision. I was going to take the court next to Paposhvili, if I may, which is in the bundle at hard copy 131, electronic 131. 132. I'm not going to read extensively from it. You'll be pleased to hear. We've sidelined the passages that are relevant, 183 to 191. Those passages begin at page 170, hard copy. I do, though, just to make good the point I've just been making by reference to what was said in AM Zimbabwe in the Court of Appeal, invite you to look at also at 197. That's the only additional paragraph I invite you to look at.
What was the first paragraph that you referred us to?
183
Thank you.
to 191, the sideline passages. And then additionally, if I may, 197. Dr. L was the specialist haematologist, and you'll see earlier in the decision there are references to that doctor's detailed evidence about availability of treatment. And you'll see they reference it there and conclude it's credible evidence. And the simple point I make is that is the taking off point for the court's application of the principles that it had enunciated earlier in the case, including the point at which the burden shifts to the returning state.
Is paragraph 186 of central importance for this argument?
Yes, 186 and 187 are the 183 is the test. 186 and 187 explain its practical application, and then
Yes, but for your argument, I mean, it's all relevant, of course, but isn't 186 the paragraph that we need to look at with central care when we're considering this particular submission? The court there sets out what applicants actually have to do.
yes.
They have to demonstrate substantial grounds for believing that they'd be exposed to a real risk, mindful that there's an inherent degree of speculation under Article 3 and that they don't have to provide
Strict
clear proof. So that seems to be what the court was saying relevant to your submission.
And that will include, as is apparent from the court's examination of the specific facts in Paposhvili, C197, that will include a consideration of what will happen if returned,
Yes, but in
and
this,
will
I mean,
there be
cutting
available
to the
treatment on
chase. Sorry to speak over you, but cutting to the chase here, it doesn't seem to have been in doubt that the appellant was in a position to show that the health services to which he has become attached are very different indeed in the other country. And you're going to submit that that's not enough to satisfy 186. Now, that's her case which is generally seems to be accepted.
Yeah, the disparities are not enough. She has to adduce evidence at this stage, stage 1, that she will not have any access or availability of mental health services available to her on return to Vietnam. And insofar as she adduced any evidence on that at all, and it was very sparing, it was Dr. Tran attempted to address it, but Dr. Tran's evidence was rejected by the first tier tribunal for permissible reasons, and my learned friend hasn't mounted an assault on that part of the FTT's judgment. So absent Dr. Tran's evidence, there was no credible evidence dealing with availability / accessibility of mental health treatment in Vietnam on return. Dr. Tran's evidence was that this essentially turned on her access to the household registration system, that's the key that unlocks access to publicly provided health service, whether it's antiretrovirals.
It wasn't just that, it's also to do with the attitude.
Sorry?
It's also due to the attitude towards mental health treatment, and leave aside the question of antiviral availability of those treatments. Anyhow, that's your case on this.
That's my case.
So that's is that what we
That's
need to look at in Papashvili?
That's Papashvili.
Right.
I'm going to go next to AM Zimbabwe in the Supreme Court at hard copy 317, electronic 318. We've highlighted or sidelined the analysis beginning at para 27, page 328. But can I, just before we look at that, can I take you to para 23 and paragraph 24? Again, para 24 endorses the point that Lord Justice Sales made about the treatment of that medical evidence by the Grand Chamber, and that was treated as disclosing a prima facie case such as to engage Belgium's procedural obligations. And then the particular point that Lord Justice Nugee identified emerges from paras 32 and 33 read together, and in particular para 33, and it's really the passage from the beginning of that paragraph down to just above the letter D.
Starts on the bottom of the previous page, really, which is the reference
Yes.
to Lord Justice Sales. Yes.
The 2 points we take from those passages are these. The first point is a point I think I've made now, that the applicant in Papashvili did adduce evidence dealing with availability, and it was that evidence which triggered the state's procedural obligations. Secondly, the Supreme Court accepted what Lord Justice Sales said at paragraph 16. And it is against that background and against the background of what was said at paras 23 and 24, that para 33 falls to be construed. And we submit the Secretary of State, the Supreme Court, Lord Wilson, clearly did not mean in that passage at 33 that there is a carve-out whereby an applicant is not obliged to adduce evidence on availability / accessibility.
That seems to be exactly not what Lord Wilson is saying there. The second sentence in paragraph 33, I needn't read it out to you, but he describes a reasonable premise to paragraph 23 guidance.
Yes,
and names the things that it's for the appellant to adduce evidence about: her medical condition, current treatment, including likely suitability of any other treatment, and the effect of inability to access it. The returning state is better able to collect evidence about availability and accessibility.
That's what it says. The returning state, no doubt, in many cases is better able to adduce that evidence, but it's not obliged to, this is my submission, unless and until the applicant makes out a prima facie case. And the crucial passage, the crucial words that give the lie to the suggestion to the contrary are the words that say, in the event that the applicant presents evidence to the standard addressed above, ... That, in my submission, clearly serves to confirm that no procedural obligation arises and no evidential burden shifts unless and until the appellant has adduced evidence to the requisite standard that covers all aspects of the Paposhvili test.
Paragraph 79.
Paragraph 79.
No, paragraph 79 of the FTT decision,
Yes.
which is what you just referred to, with Dr. Tran's evidence, was to the effect that she would not be able to access medical care, as she would not be able to register herself. You referred to this a moment ago.
Yeah. Well, that was her case.
That's right. But the judge deals with that by critiquing Dr. Tran's evidence and reaching a finding of fact about it. But isn't it the case that at that stage, according to Paposhvili and the Supreme Court, the obligation at that stage was to set up a case that was a runner? It didn't have to be a winner, but it appears to have been knocked out because the judge didn't think it was a winner.
Well, that's certainly one reading of his decision. In one sense, it doesn't matter whether you read it in those terms or in the terms I've read it. The terms I've read, by looking at everything in this section of the judgment, including para 80, it seems to me he's effectively saying the only evidence that she's adduced on this is from Dr. Tran, which I don't accept, and there's no other evidence put forward by her. And so I think the criticism has always been, well, he shouldn't have been expecting her to put forward any evidence at all. That's been the focus of the argument in this court, at least, and that's why Lord Justice Nugee, and no doubt having squarely in mind the passages in Lord Wilson's speech that we've just looked at, framed that issue for determination as warranting the attention of this court on a second appeal. And so my focus is very much on the point of principle, but I do say it's clear on the decision by reference to the FTT decision that the appellant did not adduce credible evidence to make good a case on Article 3 before the first tier tribunal.
Well, we have the ability to assess that submission, but in doing so, we would need to consider that the reports, because there are two of them and we've read them, from Dr. Tran, were not prima facie credible material about the unavailability of treatment for this appellant. Would we not?
Well, those reports, I think I have fairly summarised them when I said a moment ago. The real point that Dr. Tran made was about accessibility via the household registration system. That's the key that unlocks the door to services for free in Vietnam. And the FTT judge said it's just not credible that an appellant whose mother and at least one sibling still live in Vietnam won't be able to access a system to which she had access for the 38 years
Yes, I
that she
understand
was in Vietnam.
I understand that's
before
the
she
argument,
left.
but we're concerned here with the process, not with
Yes.
the merits. I mean, to take, for instance, in the supplemental bundle at page 102, having dealt with the registration issue,
Yes.
the expert then goes on to deal with the healthcare system generally
Yes.
over a series of paragraphs describing the healthcare system as it, in that witness's assessment, relates to this particular appellant. And it goes through a series of pages up to paragraph 45, having started at paragraph 34 to 45. So really your case is that does not represent a prima facie case sufficient to engage the transfer of the burden.
It is. It doesn't represent a prima facie case for two reasons. Firstly, comparison with the quality of service that she's been receiving in this country is clearly not the yardstick or benchmark. The purpose of Article 3 is not to relieve disparities in health services across the world, but more importantly, the evidence about the accessibility is, in my submission, inextricably linked to the household registration system. So the judge was entitled, having rejected her case on that, to reason from that absent any other evidence going to the issue of lack of availability, the appellant had not made out a case.
Those are paragraphs 28 to 33. We needn't go to them, but that's where the expert dealt with
Yes.
that issue. Yes.
That I was going to leave AM Zimbabwe. You have the point. You've seen what Lord Wilson said, and I don't dissent from the fact it can be read in one of two different ways. But I say clearly, in all the circumstances, including the way he prefaces that discussion, and against the background of what was actually decided in Papuashvili, in my submission, it's actually clear what he's saying. And in my submission, I'll come on to this in due course if I need to, but one shouldn't confuse sensible practice with principle. The principle is clear. I agree that in practice, and you may hear from a learned friend on this in reply, I think we both agree that in practice it's relatively unusual that either side takes refuge in the burden and standard of proof. There's generally evidence on both sides. There's usually better evidence than there was in this case on the appellant side. And the Secretary of State usually commissions at the very least what's called a country of origin information request directed to the country policy information team within the Home Office that says, prepare us a brief note on mental health services in Vietnam. Whatever and you'll see when AM Zimbabwe was actually remitted to the upper tribunal, that's the way both sides proceeded. No one took refuge in any points about burdens and standards. There were two eminent professors based in Zimbabwe who obviously had detailed knowledge of the health system in Zimbabwe, together with evidence from the treating doctor at the Chelsea and Westminster Hospital. So the court was in the best position possible to resolve the case on its merits. And that is clearly the gold standard. And so I don't want to be seen as commending an approach that takes refuge in the burden of proof. But you'll understand, I hope, that it's important that the principles are clear. And we say they are, and they're vouched for by these authorities. And there are good principled as well as pragmatic reasons for ensuring that an applicant does need to address all limbs of the Paposhvili test before any procedural obligation or evidential burden, call it what you will, shifts to the Secretary of State. Can I finally on the authorities on this subject take you to Safran? You'll recall from AM Zimbabwe in the Supreme Court that the Grand Chamber decision was pending in Safran but wasn't available, and an argument was raised should the court adjourn for that reason, and they said no, but they expressed the hope that Safran would bring further clarity to the issue. Far be it for me to suggest otherwise, but I don't think either of us are submitting that Safran really adds much to Paposhvili. It emphasises that Paposhvili is correct. It's the final word. It serves as a comprehensive standard, to use that language. But I should take you to it nonetheless. It's at page 182 in the authorities bundle, hard copy 183 electronic. We've highlighted the relevant passages. They begin at page 224, paragraph 130. They really do essentially repeat Paposhvili with relatively little paraphrasing. What Safran adds, I think, is by clearly identifying what it describes at paragraph, paragraph 132, it says, after dealing with Paposhvili at 129 and 130 and 131, it says there's been no further development in the case law since Paposhvili. Then underneath that, it says under the heading General Considerations, it sets out its position. It's over the page. It confirms the Paposhvili judgment offered a comprehensive standard, taking due account of all the considerations that are relevant for the purposes of Article 3. And then it restates the test. And the point I was going to make, I don't think Paposhvili had described it as a threshold test, but Safran, I think for the first time, identifies the test as a threshold test before the returning state's obligations are engaged. And saffron, in case you're not familiar with the facts, it is important to just have this in mind. Saffron, the applicant Saffron was seriously ill on any view with schizophrenia. It was clear that the absence of appropriate treatment would lead to a worsening of his psychotic symptoms. But nonetheless, the court rejected the case at the first hurdle, so to speak. And one sees that at para 147, page 228. Circumstances do not reach the threshold. That threshold should remain high against this background.
We're comparing different things, aren't we? I mean, that's not talking about the threshold for what we've been referring to as stage 1. Lord Wilson says that the stage 1 threshold is not undemanding.
Yes.
But it's not what they're talking about in 147. They're talking about the high threshold for finding
a breach of Article
3.
They are, but the point I'm making by referring to this paragraph is, they said notwithstanding the claimant's serious mental health condition and the likely worsening of symptoms absent the treatment that he was receiving.
Well, that's, I mean, you're making that point, and he had a mental illness and also a physical condition, and maybe some resonances from the present case. But I mean, what are we likely, without a minute study of the evidence in Savran and this case and a comparative approach, what are we going to gain from the fact that particular claim didn't actually succeed?
The only point of principle I'm taking from it is that you don't get into procedural obligations unless the appellant has made out a sufficiently cogent prima facie case to trigger those obligations.
Right. Well, that's the same as what we had before.
Yeah. And in this case, the appellant hadn't done that. Just pulling the threads together then from those cases, we submit the test articulated in para 183 of Paposhvili, as interpreted by AM Zimbabwe in the Supreme Court and further explained in Safran, requires an applicant to establish the following 3 conditions. First, that they're seriously ill, and that can be mental or somatic illness. Second, that there are substantial grounds for believing a real risk that if returned to the receiving state, appropriate treatment would either be absent or inaccessible. And thirdly, that this absence or lack of access to appropriate treatment would expose them either to a serious, rapid, irreversible decline in their health resulting in intense suffering, or a significant, i.e. substantial reduction in life expectancy. Condition 1 requires no further elucidation as a matter of principle or on the facts of this case. Clearly, HIV positive status is a serious illness, as is a psychotic disorder. Condition 2, absence or lack of access to appropriate treatment. You have my submissions on that. You also do have in mind the point I've made about comparability as between health systems and the standards in those health systems. Importantly, the test in Paposhvili we submit is only met where there's a risk of relevant deterioration on account of the absence or lack of access to appropriate treatment. And so we say there's clearly a causation element, and the upper tribunal in subsequent cases have proceeded on that basis, and I can show you those authorities briefly.
You're now on your respondent's notice, are you?
Sorry?
You're now on your respondent's notice.
I'm not on my respondent. My respondent. Can I deal briefly with my respondent's notice? It may.
Well, because either it's an important part of your case, in which case we need to address it in a procedurally correct manner, or, which is what you seem to have been signalling to us, it's just a nice to have.
Well,
in which case we're probably not going to need to consider it.
No,
So where does it sit?
The reason why I've given you that indication is because of the court's provisional indications
Yes.
as to its views. But can I just deal? There are 3 numbered paragraphs to it. I've told
It's number
Malone-
2.
Sorry?
I'm referring to number 2 of the respondent's notice in this context.
But point 2 goes to the severity threshold, if one can call it that. We say, taking the evidence at its highest, it didn't meet the Paposhvili standard.
Yes.
And the simple basis for that,
That's in reference to the psychiatric
correct.
evidence.
Correct. And the simple point in relation to that psychiatric evidence was that the psychiatrist said the applicant's condition would seriously, already poor condition would seriously deteriorate. And he said that was irrespective of any treatment that she would receive in available or accessible in Vietnam. So we make 2 short points, and they are very short points, and they either find favour or they don't. The first is looking at Safran in particular, but all the authorities, deterioration even from a poor state is not the Paposhvili test. That's the first point. And the second point is if that deterioration will happen irrespective of the availability or accessibility of treatment in Vietnam, then the causation requirement isn't satisfied.
Thank you.
And just on that first limb, so to speak, the deterioration issue, we do submit that the Grand Chamber in Safran made it clear that worsening even of serious psychotic symptoms is not sufficient to satisfy the standard. There has to be an express risk, we say, of the proscribed consequences, those 2 limbs of Paposhvili.
So this is paragraph 75 of the FTT decision, was the finding of fact on this matter.
Yes, we accept, we have to accept the findings of the FTT on this. The FTT clearly said we make findings in line with the evidence of both medical experts.
Right, and just say one more time, bearing in mind the gravity of those findings,
Yes.
why they don't meet the, why that sort of evidence isn't good enough.
Well, my focus in this regard is purely on the psychiatric evidence.
I know, but you're saying it's not serious enough. You referred to it as the severity or the gravity issue. Your first point here on the.
Yes, my submission is simply that the evidence said her condition is likely to deteriorate, but it didn't say in terms anywhere in the report that the condition was now or would deteriorate to Paposhvili standards. That's the point.
Right. Well, I follow the submission. Right. So that's that one.
then that's all I was going to say on that key trilogy of cases. I was going to take you, I'm conscious of course they don't bind this court in any way, but picking up on some of the submissions I made earlier about the practice in the upper tribunal, I thought it might be helpful to just show you a couple of recent upper tribunal decisions that I hope might shed some valuable light. And I'm going to actually begin with one that was commended by the Supreme Court in AM Zimbabwe, AXB, which is at 594 in the authorities bundle. This was a decision of the a presidential panel, obviously predated AM Zimbabwe in the Supreme Court, but Lord Wilson did commend, and so I should just refer you to, he specifically commended para 112 at page 620. And also, I'll just a reference for your benefit. I'm not going to take you through the passages. 123 and 125 to 125 set out that tribunal's conclusions on the procedural obligations insofar as they arise. AM Zimbabwe in the upper tribunal, again, for completeness, warrants a brief mention. This was obviously the case once it had been remitted back to the upper tribunal from the Supreme Court. It's at page 717 in the bundle. It adds nothing on the point of principle, but it illustrates the point that I made in submission earlier. In that case, the upper tribunal heard evidence, detailed medical evidence, from both parties. There were two, as I say, two professors from Zimbabwe and one treating doctor in this country, and concluded on the evidence that there was no real risk that appropriate treatment would not be available and accessible. But it did, just to pick up on the point I made a few moments ago, it did endorse the causation principle to which I referred at para 132. That's page 744. Then finally,
that was a rather special case, wasn't it, where the patient wasn't compliant.
Well,
the whole thing was the difficulty was compounded by the fact that it wasn't
correct.
It was available, but whether he'd asked for it.
He floated in and out of compliance or adherence. I think it's fair.
Not fully compliant. Yes.
But I do submit that the causation principle.
So what is, again, because I'm not sure I quite grasped it in your respondent's notice, para 2, second point, what is the causation point so far as this appellant is concerned?
The causation point so far as this appellant relates to the mental health deterioration to which the psychiatrist deposes. And he says she will deteriorate, quotes, irrespective of any treatment she receives in Vietnam. And that let me give you a.
But paragraph 73 is where this evidence is summarised by the judge.
And he deals in that first sentence with just the removal of the existing
Yes.
support structures within the community, how that would lead to a significant deterioration.
I thought
Yes,
he was saying that she deteriorate by virtue of deportation in any case.
yes.
But that's not got to do with the availability of treatments. I mean,
Well, can I just show you the passage I have in mind in the psychiatrist's report? It's at page 151.
yes.
I've read 8.9 as dealing with the fact that the appellant's mental state is liable to deteriorate if removed for a variety of reasons deposed to by the doctor. And I have, the point I'm making is he then goes on to say right at the bottom of this page, this is irrespective of what treatment may be available to her in that country.
I'm not following the logic of this at all. What the doctor appears to be saying is that deportation will make her worse, which is not particularly surprising with a condition of this kind. But he's not saying therefore there's no point in trying to treat her, or that the question of the availability of facilities would be likely to be irrelevant because there's no point in trying.
I've misconstrued it. I understood him saying she will deteriorate regardless. That's as I understood his evidence.
Yes, but it isn't the same issue. There are two quite separate things at play here, it seems to me. All right. So anyhow, that we've got to the bottom of.
Can I just, that's all I propose to say on the authorities. Can I just very briefly sweep up on the application of those authorities to the facts insofar as we haven't dealt with them, the points already. We've dealt with most of them already. You have the submissions about ARV, antiretroviral treatment and its availability in Vietnam subject to household registration. So I say that the FTT judge was right to come to the conclusions he did about that, and that's fatal to her case in that regard. And you have my submissions about the mental health issues, and in particular Dr. Tran's evidence and its rejection, and where that leaves the appellant. And that I submit is the context in which the FTT said what it said at paragraph 80, the passage that has been criticised. And I say there's nothing wrong with that passage. Having rejected the only evidence that bore on the issue, he was right to say there was no evidence adduced by the appellant to persuade the court about availability or the lack of it. There's one final sweep-up point, if I may. I mean, I'm conscious of the fact you haven't heard from my learned friend in any detail, but I'll deal with the point preemptively in case he wants to come back on it. Part of his written argument was to the effect that not only is the Secretary of State's position wrong in law, it's inconsistent with her own guidance. Now, I accept guidance is guidance. It's nothing more than that. But we thought it important to address that point. Can I just take you to the guidance? It's in the authorities bundle at page 795. And the particular passage that my learned friend relies on is at internal page 18 and 19.
I'm sorry. Could you give a reference again, please?
Yeah,
We're in the supplemental bundle,
page 8.
the authorities bundle.
I'm
I
in
beg
the
your pardon.
authorities bundle.
Hard
It'll be
copy,
elect.
so 812 hard copy.
Thank you very much.
What does that mean electronically?
813, add one.
Yes.
Those passages where the guidance identifies steps.
Yes.
My learned friend makes the point perfectly reasonably, focusing narrowly on these passages, that the Secretary of State appears to be treating availability and accessibility as a stage 2 issue or step 2 issue. But I say, not perhaps surprisingly, you need to read the guidance as a whole. And when you read the guidance as a whole, it's perfectly clear that the guidance is consistent with my submissions. And you see that most clearly at page 814, electronic 815, under the heading Assessing the Risk Facing the Claimant on Return. The second paragraph, if they claim there is inadequate or no medical treatment available in the country of return, or that such treatment will be inaccessible, the onus is on the claimant to demonstrate this. Therefore, the application form must contain relevant and reliable evidence to support their claim. They'll need to show substantial grounds, etc., which will necessarily include evidence about the lack of availability of treatment on return or lack of access to such treatment. Unless I can assist further, I was going to move on to the cessation issues. There's one other point. In fairness to Lord Justice Nugee, I don't think my learned friend addressed you on his second point of principle. Now, it may be because we can see the second point of principle relates to what Judge Lane said in the upper tribunal about CPINs. Now, it may be my learned friend hasn't addressed you because we're ad idem on that. We accept that Judge Lane was wrong to say what he said. There's clearly two distinct parts to the CPIN, an assessment or policy section and a COI section, a country of origin information section. And so insofar as Judge Lane said otherwise, he was wrong. But that's limb 1 of our respondent's notice. If it was needed, we said that was not a material error because he primarily relied on the COI parts of the report, and it was those to which he gave decisive weight. But I just wanted to remind the court that that point is part of the written argument. But I've got.
I don't think it's really a respondent's notice point, is it? Because,
no.
I mean, you're neither cross-appealing nor are you trying to uphold him on different grounds. You're just saying it's an error, but it's not a material error.
But yeah, I wanted to just flag that point.
Yes.
I haven't got anything to add to the written case on that. I'll deal with it on. Is the court content for me to proceed?
Well, I think I'm just going to consult. Ms. Hanson, it seems to us that it might be helpful if we were just to adjourn until 2 o'clock now, because that will allow everybody to have some lunch. It'll allow us to take stock. And seeing as you've now dealt with the the second ground that was being presented, we can give you some guidance maybe as to how much we need to hear from you in relation to the first matter. Good. Right. Well, we'll sit again at 2 o'clock.
Court rise in April.
Thank you.